Secretariat of the Rule of Law Development Foundation, and at our center in the Glass House, which is the Government House Banquet Hall in KOGI State. You are welcome to day 2 of the annual Criminal Law Review Conference powered by the Rule of Law Development Foundation. We want to apologize for our late start, but we undertake that we will ensure that we will speedily get through some of the key issues we'll be taking today. So before I introduce our panelists and our resource persons here, we'll commence as we usually do with the national anthem. So please can technical cue the national anthem so that we can start officially today's program. So can we have the national anthem, please? We may take our seats. May Nigeria indeed be blessed. You are all welcome to, as I said, day 2 of this Criminal Law Review Conference. You will all agree with me that we have had a very thought-provoking and intellectually stimulating conference so far. We had a very robust keynote speech from the EFCC chairman, and we had a session on substantive criminal law yesterday, where we honed in on topical areas of terrorism, freedom of assembly, and other allied issues we discussed yesterday. Today, we're moving into a very, very niche area, which is the criminalization of lawyer-client privilege communication under Section 11 Sub 4 of the Money Laundering Prevention and Prohibition Act, and reconciling these provisions with the recent decision of the Federal High Court in Aclrc versus Central Bank of Nigeria and 3 others, delivered on the 9th of July this year. And we're also looking at the provisions of the rules of professional conduct, particularly rules 55 to 74, sub 2 of the rules of conduct. And to do justice to this session, we have with us, and please give a round of applause to our chairman of session, Honorable Justice M.A.R. Oredola, JCA, retired but not tired. He has come in on very short notice. I must apologize. Mr. Yusuf Ali SAN who was to take this session is unavoidably absent. But our learned jurist is always there for the foundation, and he has stepped in to navigate this very, very, very hot topic. And please give him another round of applause. I'll soon be yielding a mic to him. Permit me to also introduce our lead speaker. Our lead speaker is a distinguished senior advocate of Nigeria in the person of E.C. Ukala, SAN. Please, let's give him a round of applause. He has extensive years of experience in practice, and he's also a member of our board of trustees of the foundation, and he's notably known as a past chair of the legal practitioners committee, disciplinary committee, which gives him more than enough in terms of a CV to do justice to the topic. We also have with us here, from the angle of the prosecutors, we have here a very, very seasoned lawyer, a learned Sikh for that matter, who is Silvanus Tahir, Senior Advocate of Nigeria. He's a prosecutor with the AFCC for almost 19 years. So this is someone who knows his onions, and we're happy to have him here to do justice to this topic. Then we also have DAUDU Anuga, Senior Advocate of Nigeria, who in fact has brought his paper. Let's give a round of applause to DAUDU Anuga, Senior Advocate of Nigeria. He's also a partner in the law firm of DAUDU and Co. And he will be speaking to us soon. He's currently in court, but I understand he will be joining us in the course of the program. We also have with us Aclrc Esquire himself. I am happy to introduce Aclrc himself because he's a former mentee of mine. He worked closely with me in his budding years of practice. And we are very proud of what he's doing in practice. He's now on his own, and his matter is the subject matter. His case, which he presented at the Federal High Court, is now the subject matter of discussion. It's an inspiration to us young lawyers and colleagues that we can make social change and we can make our mark even at a young age. Let's give Aclrc a round of applause, please. We'll be hoping to hear from him. We also have with us a representative of the Nigerian Bar Association, who is the past chairman of the Nigerian Bar Association of Buhari branch, Monday Aje Esquire. He's also a legal practitioner of 20 years post-court, and he has been involved in several trainings and workshops organized by the NBA on this particular topic. So I'm sure from the NBA angle, we are also covered. We do not have a representative of the CBN here with us. We hope eventually they will join us. I know invitation was sent out to them. So if anybody is from the CBN, please let us know so that we can have your own input. And by way of introduction, we have some notable personalities here with us. Please permit me in giving a round of applause to Paul Harris Ogbole, SAN. I think he stepped upstairs. We also have here with us Abdullahi Yaya, Senior Advocate of Nigeria. We also have with us judges of the High Court of Justice of Kano State. We have Honorable Justice Hadiza Suleiman of the High Court of Kano State. And we have Honorable Justice Fatima Adamu, also of the High Court of Kano State. We also have my lords. I've been waiting for the names from LOKOJA of my lords that are there present and those who are with us in LOKOJA. I will take those recognitions in due time. But we also have Commander N.F. Okechukwu from Directorate of Legal Services, Defense Headquarters, Abuja. You are very much welcome. So, my job has been done. I will then yield the floor to the chairman. I urge us to listen attentively and contribute to this very, very important topic we have for discussion. Thank you very much, and God bless you. Mr. Chair, sir.
Good morning, learned colleagues and distinguished participants at this morning's plenary session. Participants present physically and those who are with us virtually. As Mr. Paul Babatunde Daudu-san had already said, I won't repeat what he has said, this topic is very, very topical, apt, germane, and affects and afflicts us as professionals. Because
recording in progress.
A general never retires. So though even I'm retired, I can agree that I'm also involved. So please let us be very, very attentive, make notes. You see, one of the things you take away with at this Rule of Law Development Foundation conferences, which is held annually and has been consistent, is the rich materials you go away with will last you a lifetime. You see, the bundle of pack they always give annually like this. I have a place in my shelf where I keep them and I refer to them every now and then. So I won't make a lengthy remark now. At the end of the session or plenary, I will now make my final observations. So please, and be ready with your very astute and very, inquisitive questions. Our lead presenter today, Lanesan ECU, I call him ECU. I've known him for more than 40 years. And in fact, as I was telling him this morning, he should give me that secret, the formula, why he doesn't age. So please, he is soft-spoken, but the words are worthy and weighty. So don't lose concentration. Be with us attentively. Thank you. So, Mr. Lead Presenter, please, you have the floor. And I know you always like to deliver your paper standing.
I can give him this one so that the chair can always.
We are now 10:15, but because I want us to enjoy this particular session, because it is full of riches and benefit, we've agreed that he will speak for 45 minutes. So please be with us. See you by 11.
Thank you very much, Mr. Chairman. The ever athletic Justice Oredela retired, but never tired. Actually, while he was talking, I remembered clearly that way back in his own days in practice when we first met, he was looking exactly as he's looking now. So, congratulations. I think it's for me to copy from you rather than you looking at me to find out what the secret may be. I would like to adopt the existing protocol simply because we have very limited time. I must apologize to each and every one of you who have been here, but those who have been engaged online. I think there was a slight miscommunication. The information I was given is that my paper starts at 10, and I was actually here about 10 minutes to 10. My apologies. Now, our topic is quite topical because it affects us. If you are a legal practitioner and you have had your school meal issue with the central bank, with your bank, and they have refused to either release your fund, which you have in your account because you did not file the certificate that is called the school meal certificate, you will understand how important it is. If on the other hand, you have had your account closed because they are of the view that you must submit that certificate, which you have refused to submit, then you will understand the importance of this topic. It all derives from this topic because of the attempt to criminalize the privilege of lawyer-client communication. So we will get straight into it. The privilege actually is known to have started way back in the days of Queen Elizabeth I. Incidentally, Queen Elizabeth I reigned between 17th of November 1558 to 23rd of March 1603. That means in the 16th and 17th century. So you can see that the privilege is of great antique value. It was initially founded on the honor of the attorney, that is the lawyer, as a gentleman. Lawyers are regarded as gentlemen, and therefore they do not kiss and tell. It was not founded on the apprehensions of his clients or the need to ensure stable system of administration of justice. Now, the whole idea was that for a person to come and confide in you and tell you this is what is going on, this is the nature of my business, this is what I want to do, such a person does not expect that you go out and start telling people, or you start telling anybody without his permission that this is what he's doing, or these are the information he has given to you. In the United States of America, the right is derived from the Fifth Amendment. The Fifth Amendment was actually ratified on the 15th of December 1791 and secures rights, among others, to include right against self-incrimination, right to due process, that is life or property, in taking one's life or property. Now, it also includes right against taking, which is government must not take the private property of an individual without payment of compensation. Now, so that is how that of the United States was founded, apart from the common law, which they derived from England. In Nigeria, the right is preserved and sustained by Section 36(11) of the Constitution, as well as Section 37. There are also so many other provisions of the Constitution on which you can found that right. Then Article 8 and 9(1) of the African Charter also comes in to reinforce. Going by the content of the Fifth Amendment, more provisions of the Nigerian Constitution could be founded upon, as I have said, as providing the basis for the rights, including Section 43, which is right against compulsory acquisition of property, whether movable or immovable. Now, the whole idea, or the rationale, as far as the courts were concerned, apart from just honoring the lawyer as a gentleman, is that one who seeks advice or aid from a lawyer should be completely free of any fear that his secrets will be uncovered. This is far beyond the honor of the attorney and addresses the apprehensions of the clients as well as the administration of justice system. This is because the privilege ensures client is more willing to communicate to counsel things that might otherwise be suppressed. It helps to expand the scope of the client's privacy, allowing for clients full disclosure without fearing that it will be used against him. We need to bear in mind that the lawyer is not a police department and therefore does not need to tell a client to be wary of what he says to him, because what you say will be put in writing and can be used against you in a court of law. We don't give such caution. That is one of the reasons why this privilege is necessary. Now, clients' rights against self-incrimination, which is as much a natural right as it has become a constitutional right in most jurisdictions, including Nigeria, is secured through this privilege. Now, the client's right against self-incrimination is a right that he possesses. So it is not a right that should be taken from him by the lawyer without his consent. Because if the lawyer is disclosing, then you are disclosing against his will information that he is protected by the Constitution from disclosing. Now, the privilege helps to secure lawyers' right to receive information. Confidence is destroyed when right-minded people go away thinking the judge was biased. Now, for our own subject of discussion, it is my humble view that Lord Denning narrowly circumscribed the issue of confidence by limiting it only to the cases of bias. Because in practical terms, confidence is required for the administration of justice system to run smoothly. Without it, it cannot. So it is therefore my own humble submission that the required confidence for the client lies in the assurance that he can freely disclose to and share all information with his lawyer without the fear that the information so disclosed or shared can be used against him in the future. To me, this is the bedrock of the lawyer-client confidentiality doctrine. Now, that bedrock was underscored by Haydon. I quoted that. Under the Nigerian law, the professional privilege is provided for by Section 192 of the Evidence Act, Rule 19 of the Rules of Professional Conduct 2007, which is no longer in existence now. And these provisions have received interpretation from our courts. We cited the case of FADAC. The citation is there, which says that it avails a situation where a court summons a legal practitioner to testify on matters relating to conversation or documents he exchanged with his client. So it is not a contempt of court for a lawyer who appears before a judge under summons to say, look, I claim the privilege of confidentiality. I cannot disclose in evidence what transpired between me and my client. Actually, it is the next slide. Now, AGE2 and COP held to the same effect. But the case of Abubakar versus Chuks was rather different. In that case, the Supreme Court upheld the position that, oh, because the information that is required had already been disclosed, having been tendered as an ID in the course of the hearing, that for that reason, it means that there is no more something to be disclosed, which can be privileged. And therefore, the document ought to be received in evidence. I am still trying to find the explanation for this decision. To me, it remains questionable, and it begs the question rather than answer the question. Now, there are threats that have been posed to this privilege, and we have identified some of them. Under the 2011 Money Laundering Act, Section 25 of the Money Laundering Act, designates the legal practitioner as a designated non-financial institution with documenting and reporting obligations under Section 5 of the said Act. Failure to comply, which is failure to fulfill those reporting obligations, constitutes a criminal offense, attracting at that time a daily fine of 250,000 naira and suspension or revocation of license under Section 5, subsection 6 of that Act. Now, but this provision has been interpreted in the case of, please, next slide. In the case of CBN, yes, versus Registered Trustees Nigerian Bar Association. The Court of Appeal, in its interpretation of the Act, in the said case, protected and promoted the privilege by holding that Section 5 of the Money Laundering Act cannot be said to be intended for legal practitioners, that the type of business transaction that lawmakers had in mind when making the Money Laundering Prohibition Act could be seen in the definition of transaction in Section 25 of the Act, and found that the transactions identified therein have no bearing to any of the duties, obligations, and responsibilities of legal practitioner to his client as laid out in the Legal Practitioners Act, which laid down the procedure for admittance and the rest of them, and also the withdrawal of a lawyer certificate or striking off from the role of legal practitioners kept at the Supreme Court. That was the decision. It touched on other aspects of the provisions of that Act, including holding that the court, it created ambiguity to classify legal practitioners as non-designated financial institutions under the Money Laundering Act, when the Legal Practitioners Act had made clear and specific provisions concerning the profession extensively. The two laws, insofar as it relates to legal practitioners, cannot operate side by side, and the Money Laundering Act will illegally impede or obstruct the smooth administration of Legal Practitioners Act as amended and jeopardize the practice, regulation, and rules of professional conduct for legal practitioners. Now, on the applicability of Section 192 of the Evidence Act, the court went further to hold that the prohibition slammed on the legal practitioners by Section 192(1) of the Evidence Act covers all time events, whether in proceedings before court or other circumstances outside court proceedings, since, as it says, no legal practitioner shall at any time be permitted to. So that at any time means at any time, not only in court. They went further to hold that the provisions of Section 5 and 25 of the Legal Practitioners Act are in conflict, Money Laundering Act are in conflict with the provisions of the Legal Practitioners Act and rules of professional conduct for legal practitioners, as well as the clear provisions of Section 192(1) of the Evidence Act, and therefore held that it cannot operate side by side as it relates to the legal practitioner. The effect of that was to render the provisions of the MLA inoperative. Then later, there was a case of FRN versus Ozokume. Now it is to a similar effect. The Court of Appeal reaffirmed the position of the law to the effect that the legal practitioners are excluded from those tagged designated non-financial institutions under Section 25 of the Money Laundering Act. Now, there are still threats to the privilege as contained in the Money Laundering Act 2022, a later piece of legislation. Now, similar threats as promulgated by the Act 1922 also placed lawyers, this time as designated non-financial business, as if the word institution was a problem in the first enactment. And that can be found as Section 25, 25 of MLA 2022. Now, similar disclosure and reporting obligations in those Section 5 of MLA 2011 and 2022 can be found in Section 11 of the 2022 Act. Perhaps the biggest threat to legal professional privilege in that act is the provision that is contained in Section 11(4) of that act, which provides to the effect that legal professional privilege and invocation of client confidentiality shall not apply in connection with the purchase of or sale of land, the purchase or sale of business, the managing of client money, securities, the opening or management of bank savings, and so on, the creation of operation of management trust, and anything produced in furtherance of any unlawful act. This is quite wide. But a champion came to the rescue, Abu Arume. He challenged the provisions, and the Federal High Court upheld his position and held, among others, that the express application of Section 11(4) of the MLA 2022 to legal practitioners and notaries is in conflict with the provisions of the Legal Practitioners Act, the rules of professional conduct, and the Evidence Act, and the provisions is thus inapplicable to legal practitioners and law firms. He did not say that lawyers are exonerated from, at least at their own personal level, playing whatever role they need to play to help to fight the crime of money laundering or terrorism. No. But he is saying, this is what the law provides, and that is what we go by. The court relied on the decision of the Court of Appeal in the case of CBN versus MBA to restate the correct position of the law, thus exposing the futility in seeking to rely on cosmetic changes for the purpose of achieving fundamental results. Then came the 2023 rules. In apparent effort to cheat the effect of court decisions that protected the professional lawyer-client communication privilege, the General Council of the Bar, headed by the Attorney General of the Federation, a prominent member of the government, intervened and put in place rules of professional conduct that imposed far-reaching disclosure and reporting obligations on the lawyer, even beyond the scope of any of the MLAs. That is, that the rules of professional conduct for legal practitioners, that is the rule of the provisions of the rules of the professional conduct for legal practitioners 2023. Chapter 2 of those rules in particular dealt with anti-money laundering and finance of terrorism. Now, that provides for a set of guidelines and rules on anti-money laundering and combating the financing of terrorism for legal practitioners. The guidelines and rules appears to represent a compromise pathway between the strict demands of the lawyer-client privilege communication doctrine and the need for the lawyer to play the desired role in combating the pervading and destructive crimes of money laundering and financing of terrorism. The guidelines and rules make provisions to enable the legal profession to regulate its members in the first instance instead of the initial direct exposure to lawyers to specialized regulatory bodies and law enforcement agencies. Now, it would appear that these 2023 rules was informed by the decisions that had been given by the court, who were not ready to yield to any form of legislative intimidation. They were insisting that what has to be done right. So they now pass it on, more or less, to the profession itself. You have to do this by yourself. And with the Attorney General as the chairman of the General Council of the Bar, it was the most appropriate venue to have this done, and they did it. Now, I have drawn your attention to some of the provisions, especially that of Rule 57.1 of the 2023 rules. I've also drawn attention to other rules. Rule 53.2, a legal practitioner who fails or neglects to comply with the provisions of the chapter while rendering to clients professional services identified in paragraph 1 of the rule will be deemed to have committed a professional misconduct and will be liable to disciplinary proceedings with under the Legal Practitioners Act, or in accordance with the Legal Practitioners Act. Now, so what it has done is, rather than criminalize it by making it an offense punishable maybe through trial in court of law, it has now made it a disciplinary action. If you breach it, then you run the risk of losing your certificate. Rule 73 provides for the establishment of the MBA AMLLC with, that is MBA Anti-Money Laundering Committee, with the duties of advising the Nigerian Bar Association on implementation and to monitor compliance with the chapter. Rule 74.2 empowers the NBA AMLFC to recommend disciplinary proceedings in respect of Chapter 2 to the LPDC and the duty of every lawyer to report any breach that has come to his knowledge to the appropriate authorities for necessary disciplinary action. Now, we think that there are potential conflicts, and some of the far-reaching provisions we can identify include the following, which have potential of conflict with either the Constitution or the law. Now, Rule 60, Sub 3A, which poses a duty on the lawyer in certain circumstances to immediately identify and freeze without prior notice all funds, assets, and other economic resources belonging to the designated person or entity in his possession. The question we ask is, can such a provision stand in the face of the provisions of Section 36(5) of the Constitution, which provides that there is presumption of innocence in favor of all persons until proven guilty? We think not. Now, the designated person that is being referred to is the one published in the United Nations list of designated people, those that they have been suspecting to have been carrying out certain activities, and then the Nigerian list. Incidentally, when I was preparing this paper, I tried to assess the Nigerian list. Each time you try it, it just tells you error. It never opens up. So, but you are supposed to do this in respect of any client whose name is found there. Now, Rule 61, as it relates to the duty, relates to the duty imposed on the lawyer to inquire into sources of funds and sources of wealth of the client, and even the commercial or personal rationale for the work to be done, which appears to be, we think this appears to be an obvious affront to the fundamental right of privacy of the client as guaranteed by the Constitution. The question is, will this stand constitutional scrutiny? There appears to be potential conflict there. A client comes into your office and then he wants to establish a business, and he says, please draw up articles and memorandum of association for me. And then you say, okay, which one? What type of business do you have in mind? I have in mind, I could go into oil prospecting, put it there as one of the objects, put construction of houses, housing estates, and all that as one of the objects. Then you say, okay, look, man, you need to tell me, where do you get your money from? What is your source of wealth? I mean, I don't understand it, but it's there. Now, Rule 63, requiring the lawyer to undertake the profiling of the clients in respect of cross-border transactions based on geographic or country risks, also raise possibility of conflicts with the provisions of Section 42 of the Constitution, preserving the citizens' right to freedom from discrimination, as well as the provisions of Article 2 and 3 of the African Charter on Human and People's Rights, which also secure the right of freedom from discrimination for every individual, as well as the individual's right not only to equality before the law, but also the right to equal protection of the law. Now, in respect of that provision, what is expected is if you come from maybe a particular part of the country, I don't want to mention names. When you come and you are briefing me, I should first of all be very wary. If you come from an area where kidnapping is very rampant, is this man going to establish with his business with proceeds from the crime of kidnapping? I need to know. I need to report that. That is profiling. The mere fact that somebody comes from a particular part of the world or a particular part of the country does not mean that that person is himself a criminal. I think in that circumstance, those provisions may not stand. Now, there is also a lot of difficulty in reconciling Rule 19 of the 2023 rules, which was retained from 2007 rules, guaranteeing the privilege and permitting its disclosure only in circumstances with the objective of Chapter 2 of the rules, which by Rule 55(1)(b) expressly states is to promote the duty of confidentiality and client privilege with the rest of the provisions of Chapter 2, especially those requiring disclosure and reporting confidential communication without the client's mandate. Now, in one breath, you say you are securing lawyer-client privilege, but in another breath, you are asking that the lawyer must report on a whole lot of instructions. Once you receive certain types of instruction, once you see a person that comes from a particular area, you must do this, you must do this. So how does that promote the privilege? Now, there is also difficulty in what, with respect to Chapter 2, the promotion of the duty of confidentiality. I think I've just commented on it. Notwithstanding, my point here is that that difficulty still exists, notwithstanding the proviso in 19(2)(b), which says when permitted under these rules or required by law or a court. We will soon find out why. Section 192 of the Evidence Act, being a statute enacted by National Assembly, which protects the privilege when considered with the judicial approach of the courts in interpretation of that provision, it is obvious that the obligations in Chapter 2 of the RPC 2023 are not compatible with Section 192 of the Evidence Act 2011. In the face of the conflicts, we are now looking at enforceability. In the face of the conflicts, how enforceable are the 2023 rules? Can disciplinary proceedings be effectively initiated against a legal practitioner, and can such legal practitioner be disciplined for failure to comply with the obligations imposed by Chapter 2 of the RPC 2023? Now, I have to say here, if it was my days as the chairman of the Legal Practitioners Disciplinary Committee, I will not answer this question. But I will do so because I'm free. So my answer is no. In the face of the provisions of Section 192 of the Evidence Act, the provisions of the Constitution of the Federal Republic of Nigeria 1999 as amended, and the provisions of African Charter on Human and People's Rights, it is our humble view that it will be too ambitious a project for any person to attempt to enforce the provisions of Chapter 2 on a member of the bar. This is because rules of professional conduct made by General Counsel of the bar cannot override an act of National Assembly, neither can it override the Constitution. So practicability of fulfillment of the obligations. It seems to us that some of the obligations imposed are not practicable. We draw attention to the provisions of Chapter 2, which is Rules 55 to 74. Undoubtedly, they contain very extensive obligations, which certain legal practitioners may find burdensome, expensive, tedious, difficult to implement, given our peculiar circumstances. Now, even in the provision itself, you will find provisions to the effect that the lawyer should make the effort to train himself, train members of his staff, in order to be able to make these inquiries. A lawyer is setting up a shop as a chamber, trying to survive with his members of his family. If he's a man, his wife is not relenting. As far as he's concerned, I married a lawyer, provide like other lawyers provide. You are asking him to look for money, to go and train, so that he will be able to comply with the RPC. Where is he getting the money? He's not being paid by government. He may not even have that type of brief. How does he then start setting up the required machinery to be able to enforce it? The mere fact that the rule recognizes that it requires some form of machinery to enforce it means that it is going to be very difficult to implement. Rule 60 mandates LPs to freeze without prior notice, that is assets, to freeze those assets that I've already highlighted without prior notice. Of course, first of all, he loses the client. Secondly, there's going to be obvious litigation. Lawyer, don't seize my money, and all that. Then all sorts of stories. Nowadays, that judgments are delivered on social media before the lawyer has the time to formulate the suit. Your name would have been rubbished. You would have been destroyed forever. I gave lawyer money, and you cannot even disclose to the client, this is the reason why I am seizing your money. It is a difficult thing. Now, Rule 61 requires LPs, that is legal practitioners, to decline client requests where they lack the requisite expertise to understand the money laundering and terrorism financing risks. Then how many briefs are you going to take? Similarly, what it's doing is already creating inequality amongst the lawyers. One set can handle. You are not as trained as the other people. Rule 64, sub 4 and 65, sub 3 of the rules requires a legal practitioner to obtain affidavit of genuineness. Of course, that has its own problem. Now, we said all these attest to the denial effects on the rights of the free practice of legal profession as provided for by the African Charter. We remember that under the African Charter, you are not to be submitted to any form of restriction in the practice of your profession. Now, we have identified again that the 2023 rules are even wider in scope. We have covered that some. Can you please, the next? Yes, thank you. Now, given the broad-based responsibilities under Chapter 2 of the RPC 2023, it appears that General Counsel of the Bar simply adopted wholesale the risk-based approach guidelines for legal practitioners, for legal professionals issued by the Financial Action Task Force, an intergovernmental organization founded in 1989 by the initiative of the G7 to develop policies to combat money laundering. G7, by the way, are the countries of Canada, France, Germany, Italy, Japan, United Kingdom, and United States. Not even a single African country is there, speak less of Nigeria. But that is the model that we have decided to adopt. General Council of the Bar in its commendable effort to have the Nigerian Bar enlisted among national legal professions that are engaged in fight against money laundering and financing of terrorism, such as the Council of Legal Society of Singapore and the Council of Scotland, fail to take the peculiarities of our grown-up and indeed our legal system into consideration. Now the big question, has the legal privileges been criminalized? Prior to Abuja versus CBN, the answer would have been a resounding yes. In the face of the provisions of Section 5, subsection 6 of 2011 Act and Section 6.3 of this 2022 Act, the answer couldn't be different. However, the RPC 2023 definitely has not criminalized the privilege like the MLA 2022 did, but by virtue of 57.3, which it now becomes a professional misconduct, which renders the lawyer liable to disciplinary issues. So, conclusion. Well, we agree the scourge of money laundering, terrorism, and financing of terrorism is very debilitating and destructive and deserves all attention it can get. The executive and legislative attention being given to it all over the world is very justified. But the Germans also lay claim to it. The African idiomatic expression, goes, as the African idiomatic expression goes, you do not throw away the baby with the bath water, merely because the water has become too dirty. Indeed, another African proverb says that no matter how overgrown the hair may be, there is a limit to which it can be cut. You do not remove the hair along with the scalp. Our point is that as severe, as debilitating, and destructive as the scourge of money laundering and related crimes may be, it does not warrant the destruction of the pillars of the substructures upon which the system of administration of justice has been built, or to erode the confidence on which the justice delivery has always found a smooth trajectory. The lawyer cannot be constituted into a police informant, an unwilling one at that. Neither should the legal profession be elevated, or should I say reduced, to a police department. As we have tried to show in this paper, the issue of the lawyer-client communication privilege is too fundamental to be restructured by some cosmetic touch-ups influenced by the philosophy and thinking of a few nations whose grown-up and operating environment are far different from ours. Our efforts in attempting to set a standard at par with those other nations in our determined fight against money laundering and terrorism financing must not only take into account our own peculiarities, but must in fact be founded on those peculiarities. This, in our view, is where the RPC 2023 remains wanting and must be found wanting. I thank you for tolerating me.
Distinguished, let me welcome you back first. Thank you so much. Distinguished participants, both physically and virtually, they said promise made, promise kept. If you look at the clock, 11 o'clock. Even though, let me tell you in confidence, I'm not disclosing any privileged communication. I had already hinted him that the ex parte application he placed before me for extension of time, if needed, has been deemed granted. But at the end of the day, there was no need for such. So, distinguished participants, even those of you who are with us virtually, I want you to join us in giving another resounding, note of applause for this well-researched, well-written, and well-delivered paper. You will agree with me that we've been taken through the intricate nature and the nitty-gritty of several applicable statutory provisions which pertained to the avowed bid of powers that be to criminalize the privileged communication between the lawyer and his client. Additionally, buried landmines and pitfalls, such as the requirements which bordered on profiling and stereotyping, have been duly identified. So it behoves all of us, one and all, to analyze, digest, and plot our paths through the provisions and endeavor to keep our heads above water so that we don't go under. I know, so that is that for now. So we will now proceed, and I will call on the, okay, my list here, the next discussant now. I don't know whether Learned San Anoga is here. Okay, fine. We'll now go to learned colleague Abu Esquire, who will discuss this paper. And I want to let the cat out of the bag from practical experience. So you will have a practical touch to it. I know we are short of time, but because of the validity of your presentation, you have 10 minutes, and you've already been given additional extended 5 minutes, so 15 minutes.
Thank you very much, Chairman of Session, for this opportunity. Essentially, the lead presenter has done justice to the topic. So I'll just go ahead and answer the question as to whether the decision in Abu-Arome and CBN can coexist harmoniously with the RPC. Now, essentially, the decision in Abu and CBN was in a nutshell an invitation to the court to give expression to the doctrine of stare decisis. And by stare decisis, I'm referring to the twin decisions that were delivered earlier in the case of MBA and the registered trustees of MBA and the Central Bank of Nigeria on the one hand, and the decision of Chief Mike Ozekome and Federal Republic of Nigeria. So briefly, I would like to highlight some of these offensive sections that were declared unconstitutional, null and void by the court. The first is Section 6. Now, under Section 6, lawyers were required to, prior to any transaction involving an amount exceeding $1,000, to demand their clients to fill a standard data form and to present their regulatory ID card. Now, this is irrespective of whether this person is Elon Musk, so long as it exceeds $1,000, whether there are elements of suspicion, the reporting obligation becomes activated. Also, lawyers were required to record such transactions exceeding $1,000 and report to the Special Control Unit against money laundering. The penalty for this is 250,000 naira for every day that this offense continued. Secondly, suspension or withdrawal of the license by the appropriate licensing authority. And our argument on this particular provision was that the statutory instrument that qualifies a lawyer to be one should be the same statutory instrument that should divest a lawyer of his qualification. In essence, the Money Laundering Act is so extraneous a legislation that should determine how a lawyer should lose his license, and the court agreed with us. Next, Section 8, Section 8 and 9, I'll take them together. Section 8 requires that a lawyer should keep, for at least 5 years, records collected from his client and remit same, if demanded, by the authorities to the authorities. And by the authorities here, we're referring to the FCC and the Special Control Unit Against Money Laundering. Then Section 11 provides that lawyers are required to inform the Special Control Unit Against Money Laundering within 7 days of every transaction in excess of 5 million naira in the case of individual and 10 million naira in the case of body corporate. Now, this is also irrespective of the fact that the client in question might be the richest man in Africa. So once the financial transaction exceeds this threshold, the reporting obligation becomes activated. And the penalty is 250,000 naira for every day that the contravention continues. Then, under Section 30, lawyers were purportedly recategorized as designated non-financial businesses and professionals. This was what was known as designated non-financial institution under the MLA of 2011. And by this categorization, lawyers were compartmentalized with the likes of car dealers, hotels, mechanized farmers, jewelers, supermarkets. And our argument was that those are businesses. The legal profession is regimented, and the legal profession is regulated, and there's an act, which is the Legal Practitioners Act, which regulates it. And any statutory instrument that prescribe how the practice of law should be ought to be declared unconstitutional, null and void. Then Section 5, which seeks to abolish legal professional privileges in respect of a number of transactions, such as real estate. They are there on the screen. So the summary of our argument is that the decision in CBN and MBA, as well as the decision in Chief Michael Zekome and SAN and Federal Republic of Nigeria, already excluded legal practitioners from the applicability of the Money Laundering Act. Secondly, the Money Laundering Act sought to prescribe how lawyers should collect and keep records, whereas Section 20 and 21 of the Legal Practitioners Act, which are earlier legislations on the subject matter of law practice, already prescribe how lawyers should collect and retain information of their clients. Our third argument was that Section 192 of the Evidence Act provides that all oral communication and content of document exchange between a lawyer and his client are privileged. So requesting that lawyers should disclose the details of conversations and content of documents with a third party, whether law enforcement agent or not, was unconstitutional, null and void. Then also the defendants in that case, which is the EFCC, Guarantee Trust Bank, and the Attorney General of the Federation, as well as the CBN, their contention was that the MLA 2022, being a later legislation, had repealed impliedly the provisions of the Legal Practitioners Act, Section 20 and 21, 192 of the Evidence Act, and Rule 19 of the RPC. And the court refused to buy the argument because, according to the court, there is a mode in which statutes should be repealed, and that is express repeal. The court frowned at any attempt at implied repeal. So the court, relying on the earlier case of CBN and MBA, held that, more importantly, the Money Laundering Act, to my mind, does not directly or by implication state in any of the 25 sections that any of the provisions of the LPA is amended or repealed, either in whole or in part. So in essence, the court rejected the argument of implied repeal. Now, this is where it gets interesting. Juxtaposing the decision under review and Chapter 2 of the RPC. Now, my argument is that there's no gainsaying that the General Council of Bar, by Section 1 of the Legal Practitioners Act, is empowered to make the rules of professional conduct. I think we're all on the same page in that regard. Also, there's also no gainsaying that the General Council of Bar acted within legislative remits in enacting the anti-money laundering and counter-terrorism financing rules, which is Chapter 2 of the RPC. Now, my position is that the decision of July 19th, that's ABU and CBN, can coexist with the rules of professional conduct. I know my opinion is going to be quite controversial. And my reason is that it is not the entire offensive sections of the Money Laundering Act that was adopted. It wasn't a wholesale adoption from the Money Laundering Act into Chapter 2 of the RPC. And I sat and did a critical analysis. And I will show you some of the differences between the sections that were repealed insofar as they seek to apply to legal practitioners and the rules of professional conduct. For instance, under the MLA, lawyers were required to, prior to any transaction exceeding the threshold of $1,000, to demand that their clients provide a means of identification as well as fill a standard data form. Now, there's no financial threshold under the RPC. Secondly, lawyers were required. Secondly, lawyers were required to inform the Special Control Unit against money laundering within 7 days and in writing after every transaction in excess of 5 million in the case of individual, 10 million in the case of body corporate. Again, no such financial threshold exists under the RPC. Now, the difference under the Money Laundering Act, non-repealed, and the RPC is that the reporting obligation does not arise. Lawyers are not required to make any report to the NBA AMLC. NBA AMLC is Nigerian Bar Association Anti-Money Laundering Committee. So our reporting obligation is now to the NBA AMLC. However, lawyers are not required to, at every time, report transactions, as was the case under the MLA, to the NBA AMLC, unless there are suspicious circumstances. And there are some examples under the rules. For instance, clients who avoid face-to-face meetings without legitimate reasons, clients who have no address without legitimate reasons, clients that operate shell companies. Okay. Also, clients who have funds that are disproportionate to their circumstance. For instance, a youth corps member has just bought a plaza and wants you to perfect documents for him. At that stage, it becomes suspicious. So that is when the reporting obligation arises, not because it exceeds a particular financial threshold. So also, under the MLA, the practice was for lawyers to collect information from clients and report to the Special Control Unit against money laundering for the SCUML to form an opinion whether the transaction is suspicious or not. However, under the Rules of Professional Conduct 2023, the obligation is for the lawyer to form an opinion as to whether the transaction is a smoke screen for money laundering. So the obligation is for the lawyer to form, not for the lawyer to collect information, transmit to the SCUMO to form. So discretion has been given to the lawyer. Now, if we oppose the provision of the anti-money laundering and counter-terrorism financing rules, then we are indirectly attempting to shield clients, even when it is patently clear that their goal is to commit crime. Now, the basis for which we succeeded in our case at the Federal High Court was that Section 192 and Section 19 of the Rules of Professional Conduct guarantees lawyer-client privileges. However, those provisions admit to exceptions. And the exceptions are that where the communication is made in furtherance of an illegal purpose, the client is no longer entitled to confidentiality. So it is this exception which we all agree that exists that was adopted into the RPC 2023 Chapter 2. So in rounding up, lawyers are gatekeepers. And this is because we render legal services to a lot of high-risk clients and politically exposed persons. And as such, we all agree that lawyers can become channels through which illegitimate resources can become legitimate. Now, what we have achieved so far by the judgment and by the RPC is that we have been able to put an end to the era of external regulation of law practice. The argument before now is that it is the NBA that is empowered to regulate law practice. And the General Council of Bar, we all agree, by virtue of Section 1 of the Legal Practitioners Act, can make rules for law practice, which they have done by enacting Chapter 2 of the RPC. Also, the era of unnecessary reporting, that once the transaction exceeds $1,000, whether Dangote is my client or not, of whom $1,000 is a paltry sum to, doesn't matter. So we've been able to put aside the era of unnecessary reporting. So in closing, I'll be asking this question and I'm going to answer it. Is the General Council of Bar, by virtue of Section 1 of the Legal Practitioners Act, empowered to make the rules of professional conduct? The answer is yes. Does this power extend to making anti-money laundering and counter-terrorism rules? The answer is also yes, which they have done. So the only thing okay, in closing, the mic is trying to tell me that my time is up. So in closing, the only thing I frown at is the idea of me asking my client how you made your money. I think that question is off-putting, and it can be embarrassing to the client. Thank you very much. Thank you. Welcome.
Distinguished participants will agree with me that that's another well-delivered or well-discussed presentation. So please, the round of applause preceded my request for it. So now I'm requesting for another round of applause for the discussion, for a well-delivered paper. And you will, one takeaway from his presentation, and which is beneficial to all of us, is that now the NBA regulates legal practice, discipline legal practitioners, just as the National Judicial Council regulates and disciplines judicial officers, judges, and justices. And I think we should be in a better position to deal with ourselves. We'll leave it at that for now. So I now call on Lanet San, Sir Silvanus Tahir, representative of EFCC, to discuss this lead paper and maybe observations and comments on the discussion which we have had from Abu Arame. So, podium is yours, sir.
My Lord, the chairman of this occasion, Learned Senior Counsel Isi Ukala, the lead presenter of this paper, Mr. Abu Arume, a co-panelist, other co-panelist, the host of this event, Mr. J.B. DAUDU, SAN, and his team of faculty members. Ladies and gentlemen, good morning. Well, we are delighted to be invited to this event. And this has been a continuous exercise. And we commend the organizers for this elucidating forum for lawyers to x-ray issues of topical issues of national and even international dimensions. Now, I submitted my paper, which comprises of 31 pages. But I'm not going to speak to the entire pages of the presentation. We have heard from the lead presenter the able x-ray of the topics. He has dealt with it. He has done justice to the concept of lawyer-client privilege communication, the historical development, the practice as it is, and the attempt by legislation to take away the privilege donated to the lawyer by the Evidence Act to keep in confidence the communication between the lawyer and client. I am of the official bar. Before I came to government, I was in private practice. I know what obtains in private practice, which I cherish, and upon my quitting government, I will still go back to legal practice. I have seen some things in the official bar and in the government cycles that some of our colleagues might not have seen, particularly as a prosecutor with the Economic and Financial Crimes Commission, of which I have served since August 2005 till date. We have seen a lot, and we are not uninformed as to global developments. And so from my position as a member of the official bar, we have had the argument canvass as to why the lawyer-client relationship or confidentiality clause as provided in the Evidence Act should be retained and shouldn't be tampered with. Being from both sides, I quite appreciate all that has been said here. There's no doubt that there's a need to protect lawyer-client communication. That one is beyond argument. But the question is, in the face of global development, and given the fact that Nigeria belongs to a committee of nations, and the fact that globally there has been developments which warrant tinkering or taking a second look at the confidentiality law, can Nigeria afford to remain an island unto itself? That's the critical question. We'll all recall that until 9/11, 2001, when the US terrorist attacks took place, whereby planes were hijacked by terrorists, 19 terrorists who belonged to the Al-Qaeda movement. The skyscrapers of New York at the World Trade Center, the Pentagon, and other critical infrastructure of the United States were bombed by terrorists. It was then it dawned on the world that we live in an era of terrorism. Apart from terrorism, we have money laundering. We have instances which is replete in our jurisprudence whereby politically exposed persons, government officials, dip their hands into the till, steal monies, and launder them. And from evidence, not just within Nigeria, but outside Nigeria, these monies are laundered through different channels. And if you go through the Money Laundering Prevention and Prohibition Act of 2022 and the act that preceded it, the 2011 Act, you see categories of people that are used, or businesses that are used to launder funds. Jewelries, car dealers, realtors, accountants, and some other professionals and persons. And that was what informed the enactment of the Money Laundering Act of 2011 that categorized legal practitioners as designated non-financial institutions, but which has been restyled as designated non-financial business and professions under the 2022 Act. Now, lawyers, no doubt, are gatekeepers. Clients do patronize us. And some of them, whether we know as a matter of fact, or we feign ignorance, or we are deemed to constructively know that they are politically exposed persons who launder or who use our offices to launder money. The Act now decided to include lawyers as designated non-financial business and professions, notwithstanding the judgment of the Court of Appeal in the case of registered trustees of the NBA against the CBN and the Attorney General of the Federation. That is to tell you how bad the situation is. Now, like I said earlier, Nigeria belongs to a Committee of Nations. The law that the Money Laundering Prevention and Prohibition Act was made pursuant to the UNODC, United Nations Convention, no, UNTOC, the United Nations Convention on Crime, Terrorism and Crime. That was what gave birth to the Money Laundering Prevention and Prohibition Act. Nigeria is a member state of the UN, and we are signatories to both the UNCOC and UNTOC Act conventions, which battered the Money Laundering Prevention and Prohibition Act. Now, the question is, do we stand aside out of the Committee of Nations and say, okay, we, because we have lawyer-client privilege in our act, our domestic legislation, we cannot subscribe to the, or be feel bound by the United Nations conventions. The learned Sikh, in his presentation, alluded to the fact that the Money Laundering Prevention Act gave birth, which we find in our laws, is a product of the thinking of few nations. But I beg to disagree. There are like more than 200 countries that are signatories to those conventions. Oh, maybe I didn't get it right. I thought you said few countries. Yes. Okay, the Part F. Nigeria is a member. The G7 countries, yes, I understand that. Yes. Okay, but the Part F comprises of several nations. Okay, the G7, yes. And their convention is right now taking place somewhere. Yes. Yeah, it's the product of thinking of few nations. But thereafter, other nations came to sign as signatories to the convention. So the point I'm making is that, can Nigeria isolate itself? Okay, can Nigeria isolate itself? Because if we belong to the Committee of Nations and far-reaching legislation designed to protect the world from terrorism and money laundering is passed as a convention to which we are a signatory, can we now say we cannot be part of that convention? That's the question I'm asking. Now, I have mentioned that the paper has been well x-rayed. So I now just go to page 21 of my presentation. And it has a subheading, which is the implication of the exemption of legal practitioners from complying with the Money Laundering Prevention Act of 2022 on Nigerians' quest to exit the grey list. Now, over the years, That's page 21 of my paper, if it can be projected, from page 21 to the end. Over the years, Nigeria has been plagued with the menace of corruption, money laundering, terrorism, and terrorism financing. The menace of corruption, money laundering, and terrorism has negatively impacted Nigeria and affects foreign direct investments, FDI. And many citizens have been displaced from terrorist and banditry attacks. The Part F, an international body, set global standards for the fight against money laundering, terrorism, and terrorism financing. And countries are under an obligation to implement these standards and domesticate them in their national legislation, which is the point I was trying to explain. The 40 Part F standard recommendations contained in the Part F Revised Standards 2012 are inspired by the United Nations Convention on Transnational Organized Crime and the Palermo Conventions. Nigeria, being a signatory to the United Nations Convention against Transorganized Crime and the Palermo Convention, is therefore under an obligation to domesticate the resolutions contained in those conventions. The Part F recommended 22 of the revised 40 recommendations, designated legal professionals, notaries, amongst other entities, as DNFBPs, and considered them vulnerable to money laundering and terrorism financing. The Part F recommendations are measures countries are expected to implement to safeguard the global financial systems and prevent abuse by criminals of legitimate businesses and professions, including the legal profession, from being used to launder money and finance terrorist acts. It is necessary to point out that here that countries that do not or domesticate the Part F standard recommendations or incorporate them into their AML-CFT legal regime are liable to sanctions by the Part F by issuance of a public statement against such erring countries as non-cooperative and compliant territories, NCCT. That's non-cooperative and compliant territories, NCCT. After the issuance of a public statement for non-compliance to its 40 recommendations, the Part F blacklists the country, indicating that the country is a haven for money laundering and terrorism. Nigeria has been blacklisted twice, in 2008 and 2011 by the Part F, until the year 2013, when the gaps in the Nigeria Anti-Money Laundering and Terrorism Prevention Act of 2011 were identified and remedied by the Money Laundering Prevention Act, that's the Amendment Act of 2012. That's to remedy the situation which led to the exit of the country from the Part F. But we have relapsed. We are now back to the Part F, to the blacklist. That's the gray list. The effect of the Part F blacklisting a country devastates the country, and it is important we listen to this. The effect of the Part F blacklisting a country devastates the country in terms of damage to the country's reputation, as such countries are regarded as a territory sponsoring terrorism and a haven for money launderers. Besides the damage to the image and reputation of the country under the Part F sanctions, the country blacklisted suffers from economic consequences ranging from withdrawal of corresponding banking relations with counterpart financial institutions abroad, like the JP Morgans, the Lloyd banks, the whatever bank you can think of, either in the US or in the United Kingdom and other parts of the world. There are consequences because once blacklisted from economic consequences ranging from withdrawal of corresponding banking relations with counterpart financial institutions abroad, it diminishes capital importation coming from foreign direct investments and triggers capital flight from that country. Between 2008 and 2019, Nigeria suffered the effects of these sanctions imposed by it by the Part F until 2013, when Nigeria was removed from the Part F grey list. The just concluded Part F plenary held, that was last year on the 24th of February 2023 in Paris at the OECD in France, the effectiveness in its AML-CFT regime and placed Nigeria on enhanced Part F and GABA monitoring. Right now we're under the radar of the Part F and the GABA. That's a regional body based in Senegal. The Money Laundering Act of 2022, which domesticated the PATEP recommendation 2022 on the revised 40 recommendations, which designated legal professionals, notaries, amongst other entities as DNF BPs, and considered them vulnerable to money laundering and terrorism financing, is stricto sensu not in conflict. That's our submission. Is stricto sensu not in conflict with the clear provisions of the LPA and the RPC, as the rules mandatorily provides that legal practitioners are to uphold and observe the rule of law, promote and foster the cause of justice, maintain high standard of professional conduct, and not engage in any conduct unbecoming of a legal practitioner. And this can be found to the exceptions under Section 192 of the Evidence Act. The Legal Practitioners Act of 2007 are the primary legislations, and the RPC, the Legal Practitioners Act of 2004, and the RPC 2007 are the primary legislations that regulate legal practice and the conduct of legal practitioners in Nigeria. The RPC rates the interests of the law. The RPC rates the interests of the law over and above that of a legal practitioner's client. So the rule of law is supreme over the privilege of a client to have his communication kept quiet or under anonymity. The RPC rates the interests of the law over and above that of the legal practitioner's client, to the extent that the legal practitioner is expected to operate strictly within the law, notwithstanding any contrary instruction from his or a client. And where the client insists on breaching the provision of law, the legal practitioner is mandated to withdraw his service. In the same vein, the provisions of the Money Laundering Act of 2022 are designed to strengthen legal practice and ensure accountability and transparency in relation to legal professionals' duties to their clients. I know this may be debatable and it may be disagreeable to our colleagues in the outer bar. DNFBPs has the same meaning as designated financial institutions, which was used in the Repeal Act of 2011. However, the 2022 Act interpretation is more elaborate, as it includes additional businesses and professions. So if you look at Section 11, the list of DNFBPs are numerous. It doesn't only include legal practitioners. So under the 2022, the definition is more elaborate, as it includes additional business and professions. DNFBPs under the new act therefore cures the lacuna or seeming confusion that was created by the decisions of the court in CBN and the NBA, registered trustees of the NBA, and the Ozekome case, to the effect that legal practice and legal practitioners did not fall within the contemplation of DNFIs under the Money Laundering Act of 2011. Furthermore, as part of the legal practitioner's duty to represent a client within the bounds of the law, he shall not counsel or assist his client in any conduct that he knows to be illegal or fraudulent. It is therefore imperative to state that the Money Laundering Act of 2022 merely reinforces these duties that have been handed over to legal practitioners by both the LPA and the RPC. That's our submission. The provisions of the 2022 Act can operate side by side with the operations of the LPA in the regulation of legal practitioners. The introduction of Section 11 sub 4 of the 2022 Act has effectively qualified and listed specific functions whereby a lawyer-client privilege cannot be invoked, and thus has effectively put to rest the furor that arose from the decisions of the court in the earlier case of CBN and the registered trustees of the NBA, as well as the case of Ozekome, as the specific activities listed in Section 11.4 of the Money Laundering Act of 2022 are not duties or transactions exclusive to legal practitioners. So the point we are making here is that when you look at the transactions listed under Section 11, it is not only lawyers. We have accountants, we have realtors, we have car dealers, we have jewelries. If a lawyer is doing his normal normal duty of a lawyer, you are bound by the privilege. You don't divulge whatever information you get. But when you stray out of your way to do other businesses that other professionals and businesses are doing, does it stand to reason to say, okay, because I'm a legal practitioner, I'm not bound by the provisions of the Act because of Section 192 of the Evidence Act? That's the question we are posing. The American Bar Association, for instance, has consistently resisted every effort to impose AML requirements on the legal profession. Their principal objection is that many of these requirements, especially the requirement that mandate entities to fill SARs, that's Suspicious Activities Reports, with the government authority, conflict with the lawyer's ethical duty of client confidentiality. A legal practitioner is under obligation not to reveal information gained in the course of representing a client to outside parties. There's no doubt about that, including the government, save in very narrow set of circumstances. The duty of confidentiality is related to, but distinct from the lawyer-client privilege, which prevents a lawyer from testifying against his or her client in court regarding private communications that the lawyer had with the client in the course of legal representation, or providing such communications in response to a discovery request. Some have argued that extending the mandatory reporting requirement to legal practitioners compromises their ability to guarantee confidentiality, which is the point that the lead speaker stressed, as also supported by Abu Arume, and thereby discourages the full, frank communications between lawyers and clients that are essential for effective legal representation. The legal practitioners have a valid concern, which we concede, but only to a point. A broad and unqualified extension of the AML-CFT reporting requirements to lawyers could indeed impinge on traditional and important principles of lawyer-client confidentiality. But this is not a reason to leave things as they are. Rather, the Act, that's the 2022 Act, and its implementing regulations can and should draw more nuanced distinctions, imposing AML-CFT requirements on lawyers when those lawyers are acting principally as financial advisors. So we are submitting that if you find yourself as a financial advisor, there are law firms in our climb here that act as transactional lawyers, not traditional lawyers that go to court to represent their clients. If you delve into transactions, as some lawyers have, why would you want to shield yourself?
1 minute.
Sorry, my lord. So the argument has been canvassed, and we submit that these points should need to be taken holistically. We need to rethink. Now, in closing, it is important to keep in mind that while the case for a strong duty of confidentiality arises principally in the context of traditional legal representation, most obviously in litigation, lawyers who perform services that are typically associated with financial advisors and intermediaries, such as setting up companies and trusts, structuring transactions, or advising clients on how to do so, and the listed services in Section 11.4 of the 2022 Act don't have good reason to be exempted from the AML-CFT requirements, especially when those requirements do not and should apply to other entities that provide virtually identical services. Well, our final submission is that no stranger will build our country for us. We are the ones to build the Nigeria of our dream. While the debate lasts, it is important to remind ourselves that the two decisions in the registered trustees of the NBA and the CBN, and the latest decision in Abu Arume and the CBN, still remains the law. So, but there are issues, like I said. Nigeria is currently on the gray list. How do we exit the gray list? Because they benchmark other countries. Once they have a list, they tick whichever you have complied with. If you have not complied, you remain in the gray list. And the disadvantages are obvious. Even senior lawyers like Isi Ukala that have foreign dimension of handling cases. One day, you will even find it difficult to get your fees. So that is our point, and we pray that the bar, notwithstanding the chapter 2, the Ukala in his lead paper made a submission that those provisions are like dead on arrival because there's no machinery of enforcing it. It is just mere professional misconduct. I pray that we will all take a second look in the interest of the country, not just in the interest of the clients. Thank you for your attention.
Thank you so much. Round of applause for Learned San for that passionate delivery. And you will agree with me that we've heard something from, for now, I will say from the official bench. So please, another round of applause because it was practical and very invigorating. Thank you. So we'll proceed now and take the next discussant before we go to the interactive section. I please plead with you that we will bridge the time for tea break. So, but let's have the full benefit of the presentation that will be done by Mr. Monday Ajay, the former chairman of NBA Buhari, who is a representative of the NBA. You also have 15 minutes like the others so that we can stop at 12 noon or thereabouts.
Mr. Chairman, sir, for purpose of want of time, may I adopt the already established protocol? But without giving respect to whom respect is due, let me quickly, with all sense of humility, appreciate the lead presenter. Some people prefer to call him chief, and he has debunked that on several occasions. But let me stand with what we have here. Our own River Isi Ukala, Senior Advocate of Nigeria, for a job well done. You see, when you call an expert of his status to lead a discussion of this nature, you begin to wonder, what are you going to say? Because he has discussed the paper, he has presented the paper, he has given clue to all what others are coming here to see. But God forbid that we also appear here and we'll tell this August gathering that we have nothing to say. Let me quickly make some clarification before I proceed, sir. On the issue of this idea of international conventions that we always hide under to perform some miracle in quote in Nigeria. International convention, no matter how beautiful and good they are there to comment our law, as to complement our law. It's not to take over our law completely. So this idea of we belong to international community, and what happened at international community should take over the provision of the Constitution and act here. I think that argument does not really fly. And secondly, we have been maintaining our position as a professional body. No single sane person that will stand anywhere, not even in any motor part, to say that they are engaged any government effort fighting all form of corruption, be it laundry, money laundering, or whichever way we can think about. Nobody, except somebody who is not really normal. So we are all for the same cause. But the challenge and the position that we keep on addressing, which have not been resolved, and that is why we are still here, is that even in the course of fighting this war, this war against this money laundering, that's what I mean, there is need for us to follow due process of law. Otherwise, all our effort will be a waste. Anything done without regards to law is an effort in futility. Now, take an example about what happened since 2011. We have been talking about this act. It was amended. Now we are here. There are court cases, Federal High Court, Court of Appeal, in respect of this same provision that mandated or compelled a lawyer to to now serve as an agent or a department or some of these institutions who are specially trained, paid to carry out certain specific work for the benefit of both lawyers and the society. And now you are now shifting the goal. It's just like a situation whereby a parent who has failed in his parental responsibility now rushed to school and he was talking to his teacher. Why did you refuse to direct my children to go in this way and this and that? Meanwhile, you are the parent. You owe your child a duty to do the needful. It should not be transferred to a body like MBA. And let me also correct this certain impression. We are talking about the issue of privileged informations, that it's not only lawyer that is incorporated into this action, that even accountants, even car dealers, jury dealers. But I beg to disagree that the profession of the Evidence Act is not talking about accountant. It's not talking about jury business or what have you. It's being specific about the particular profession. And such professions should enjoy that statutory immunity. And that is why we are here. We are not saying we are not in support of this move, but we cannot, by any act of ourselves or any institution, override the provision of the law, the constitution, or the act itself. That's what we are saying. So this idea of saying that is a collective effort, we must all put our hands together. Nobody is removing his hand. We are all together in this cause. But we must follow the law in the course of fighting this cause. Otherwise, we won't get anywhere. Now, let's look at what has happened now. Even with the regulating law given to us, rule of professional conduct by our parent regulating body, when you look at it critically, you will discover that there is no job done. Because if indeed we have taken our time holistically to examine the provision of the existing law, together with the decision taken or delivered by our courts, you will discover that most of what we have achieved is just what we have succeeded in doing is just to take the punishment meant for that legal practitioner from a criminal realm, from being punished or being criminalized, than mere professional disciplinary action. And when you also look at it critically, you will discover that there is nothing you can punish a lawyer about. If the law says you cannot go beyond this scope, I see no reason why RPC will now substitute its own position against an existing act, which says this group of people should not be part of this move. Simple. Now, if I may ask, it's as if without lawyers in this fight of corruption, especially disclosing their clients' financial information to EFCC, it's as if EFCC and other agencies involved cannot fight their cause. And I beg to disagree. Because this other claim we are even making reference to, this convention we are copying and we are pasting into our system, when you look at them holistically, you will discover that their method of pursuing this particular cause ahead of us is quite different from our own. Our own, we like going to social media, we like going to public, instead of us to go through the route. All this money we are talking about, how can a person carrying billions of naira from Aclrc to Abuja here? Of course, there are modes by which this money are being transferred. These are the areas that this agency is supposed to torchlight and put an end, not for them not to be looking for an assistance where there's no need. I imagine, how can somebody approach you? Let's not even put law aside. Let's apply common sense. Somebody approach you as a professional. Let's just go a bit lower. You are there as a tomato seller, and somebody came to buy your product. You are now asking, this money you want to pay me, ma? Can you tell me how you get this money? I want to know the source of this money before you buy my tomato. It doesn't add up. It's just like professional body too. Now somebody has come to me for my professional work. And then the next question that should come to me as a normal man is, okay, sit down. I'm going to take this your brief. But the way I look at you, you look like somebody from Boko Haram zone. And I must get to the root how you get this money you're going to pay me. EFCC and other agencies are being paid from government money. Our own is what you work that you get. We are not saying we should close our eyes against some of these things. But what we are saying is that what is not possible is not possible. We don't need to waste much time about this. And when you look at all the entire provisions that we have, it's just to protect lawyers confidentially as regards the relationship they have with their clients and themselves and their chambers. Because the moment a litigant or your client appear to you and have this mindset that anything I'm going to say, just like what we used to do in police station, will be used against you at any time. Of course, if you are a smart person, that will be the end of the story. You won't disclose all what is in your mind. And then, are we succeeded in finding the cause at that moment? No, because the person will not even tell you what he has in mind. So, either way you look at it, the onus is still on the agencies to do their bit, to step up their games and stop this idea of sentiment. I call it sentiment because at times it's not about bringing in sentiment that are we not feeling the hurt of this corruption, this money laundering? Of course. I just returned from Ondo State yesterday for the election, whatever. We saw it daylight, how politicians are buying votes. In fact, they are negotiating. Give me 7,000. No, I will not take 7,000. Give me 10,000. The agencies are there watching the whole drama. I even confronted them. They said, Ghana, so they do their thing, leave them. So it's only lawyer that is so important in this fight that they cannot be pushing to fight this cause for them. So they have enough work outside there and people that they can use. I think there's one trendy video now from the same Ondo State when they approached one woman who said, well, this election was peaceful. But what happened is that they have paid for my service and the people that have paid for me have voted for him and have collected my money. What's up EFCC or ICPC to go through that woman now and get the person who now draw that money down? Now you're waiting for when that mama will come to me that I want to do an agreement about my land. And I will not be, Mama, tell me how do you get this your money? I want to know the source of your money. When EFCC and IFCC know the source of this money, we are all aware about primaries of various political parties few years ago. How people were exchanging dollars and pounds in the same primary. And EFCC was there with their red, whatever, monitoring everything in the name of monitoring. And nothing has happened. But it's as if there's one unique thing about this lawyer thing. As if lawyers is the root cause of the whole thing. So I want to say, mine is not to present any paper. It's to analyze, discuss what has been presented. So from my own angle, I see it that instead of wasting our time pursuing a cost that we cannot achieve, even now and near future, the only option left for EFCC now, or any agency in charge, is to go to the National Assembly to go and amend the law. If the law says, henceforth, this is how it's supposed to be, I can assure you, everybody here, we don't have option. We'll go. But if we are now saying the law is this, of course, this moment, we still agree that the law as it is as what has been decided by the RMI case. And if there's nothing against that, the law stands. So what are we discussing now? Are we now going to change the law just to suit that because we are in a hurry to pursue a cause until we comply with that law? And I can say, as a matter of law, that we must do the right thing at the right time. The only option left for us now as a body, as a institution, is to go to National Assembly, which I doubt because most of the actors that are there too, their hands are also tied because they know that this is against them. Is to go there to do any miracle we can perform, to force them to sign a law that amend all these things so that all of us will be involved. Until that is done, I'm not sure we can really make a headway. And in conclusion, let me say this, that MB as a body, we are willing anytime, any day. Luckily, the man from MB, from EFCC is also a member of MB. If we cut him off from MB now, it's all from EFCC. So we are everywhere, and we are doing our best to make sure that this cause, this terrible thing that we are fighting, money laundering, is put to a barest minimum. NBA has never, for once, come out to tell the world that they are against that fight. No, we are always in support. So, but what we are saying is that we must act within the purview of the rule of law. As anything done outside the purview of rule of law, will yield no positive result. And that is our take as a body. Thank you for the audience. And I pray that God will help us and deliver us from the hands of the money launderers and we'll be able to do the right thing at the right time. Thank you very much, sir.
Thank you from the practical explosion.